My name is Sheila Ward, and I'm the Director of Communications and Membership for the American Society of International Law. I want to welcome all of you here tonight. We're very pleased to be able to host this series of human rights continuing legal education classes in conjunction with American University's Washington College of Law. For those of you who are not already familiar with this society, we were founded in 1906 as a nonpartisan, nonprofit educational membership organization. Our members, even with the American Society of International Law, really come from all over the world. They include scholars, students, and practitioners in the field. And our mission is really to foster the study and the use of international law, and we do so through our publications, like the American Journal of International Law, which I'm sure most of you have certainly heard of, if not read and referenced before, and also through events such as the one we are hosting tonight. If you aren't already a member of the Society, I'd certainly encourage you to consider joining us. I think there's a member brochure in everyone's seat, and whether or not you decide to join us today or in the coming days, certainly hope you will continue to look at our calendar of events and continue to come and visit us here at Tiller House. We have events throughout the year here at our headquarters, and we'll be having our mid-year meeting in Atlanta and Athens, Georgia this coming October. So without further ado, and all information about all of this can be found on our website, asil.org. But without further ado, I'd like to turn the program over to our distinguished moderator, Dean Fabio Grossman. Thank you.
Well, first of all, we're very honored to team up with the American Society of International Law to have today presentations and discussions concerning the future of the International Criminal Court, the Lubanga judgment, and we're honored to have this discussion because of the standing and importance of the American Society. It is a crucial domain where the international law could be analyzed, the theories underlying important principles and developments of international law, where scholars, practitioners from all over the world come together and analyze the issues facing the national system. As you know, we are almost the Academy of Human Rights and where we have a series of events, including 10 courses in English and 9 courses in Spanish, attracting more than 100 people and scholars, judges, practitioners all over the world. And we cannot think of a better partner for us to promote these important values of international law. That reason would be enough to feel honored for this opportunity. But there are other reasons as well, and all of them are valid. The second is the personalities of the two scholars, judges who are here. I'm going to talk about the future of the International Criminal Court. To my left is Judge Sylvia Steiner of the International Criminal Court, whose resume you can read in the materials presented, and both speakers do not need introduction. It's very important to listen to what they have to say today. And we have, to my right, the Fausto Pocar, who is the appeal judge of the International Criminal Tribunal for the former Yugoslavia, and from Rwanda, past president of the The topic that convenes us today is the first judgment done by the International Criminal Court in the case of the prosecutor versus Thomas Lubanga. And anything that is an issue the first time is important for the court. There are procedures, mechanisms that no matter how wide were the drafters of these instruments were not foreseen. And within strictly within the proceedings of the court and the legal authority, the court has to be the important issues that have been foreseen on the prior consideration. There are also, and we are going to hear that but in addition to technical issues and interpretations advanced by the court, including the dissident and concurrent I think that from the point of view of the world order, it's also crucial to hear from them the context in which this was approved, the selection of the case, the impact that has in order to fight impunity and in Africa and in the world as a whole. So I'm sure we will have the chance to discuss in what way this first crucial decision influences what we do in the areas of fighting impunity and accountability and contribute to the motion of the law. I want to offer first the floor to Judge Tanya on 20 minutes, and then at the same time with the Judge Tanya.
Thank you very much. First of all, my friend, Dean Grossman, for being here and moderating this, not this debate, but this conversation. I would like to thank very much to the Society of International Law in the person of Professor Elizabeth Anderson. I feel honored by this invitation. Contrary to what I hear Dean Professor Claudio Grossman says, I'm not a scholar, I'm not a professor, I'm not a teacher. I used to say and I'm proud of that, I'm only a judge. So I want since now to apologize if I'll try to give some of my opinions in relation to the first case that came to a decision on the merits at the International Criminal Court, the Lubanga case. Why, in my personal opinion, this is an important landmark, not only for the International Criminal Court, but as well for international criminal law as a whole. And at the end, try to show you why I'm so optimistic. I'm looking at my dear friend, Judge Fausto Polcar, because yesterday he suggested me if we could change the subject of this conversation and say the future of International Criminal Court, if any. So I will try to show you that. So I was kidding. I'm a kind of person that also always see the glass half full and not half empty, and this is why what I want to try to transmit to you in this very, very brief presentation. The first and most important criticism against the International Criminal Court as a whole, and more specifically now in relation to the Lubanga case, was the length of the proceedings. And apparently this is something that, at the eyes of some people, would justify crucial or substantial changes in the statute, in the Rome Statute, in the rules of procedure and evidence. And I can say that the Assembly of States Party is very concerned because of the costs of such a lengthy procedure. And I would like just to say that not as a justification, because when we start with many justifications, this can give the impression that we are agreeing with the criticism, and I am agreeing just only in part with the criticism. The case against Mr. Thomas Lubanga Dyilo was the first case of the court. It started really in 2006 when Mr. Thomas Lubanga Dyilo was transferred to the court after the issuance of a warrant of arrest by Pretrial Chamber 1, which I belonged at that time. It was the first case for the International Criminal Court after 3 years functioning of the court, in which no cases, no investigations were undertaken by the prosecution. The prosecution brought a case with just one, let's say, one kind of charge. As a matter of fact, what three charges, but all of them involving the conscription and the use of child soldiers in hostilities in the Democratic Republic of Congo. The confirmation of the charges against Mr. Thomas Lubanga Dyilo took place 1 year, 2 months later, which for a preliminary phase of a case, of a judicial case, we can say, yes, it's a lot, it's too much, when we have in mind, we bear in mind that the suspect at that time was detained. Maybe a justification in this case, the first case of the court, no precedents in which the court could base its findings, and the ICTY and ICTR, we never had a pre-trial chamber or a pre-trial procedure. We had a pre-trial judge in charge of analyzing the evidence brought by the prosecutor and issuing the warrant of arrest. We have this, our statute and our rules provide for a pre-trial procedure that is supposed to work as a filter in order that cases that cannot possibly succeed in trial go to trial. So it's exactly in order to avoid a length period in prison. It's not in order to avoid a costly procedure that is fated to fail at the end, that the pre-trial phase was established by the legislators of the statute and the rules. The case of Thomas Lubanga Dyilo went to trial, and it's true that the trial took really, really long. The decision on the merits came in 2012, meaning 6 years after the detention of Mr. Thomas Lubanga Dyilo. Of course, the judges of the court are familiar and are fully support the principle that expeditiousness of a trial is one of the components of fairness of a trial. However, it's important to notice that in three occasions, the trial of Mr. Lubanga was suspended, exactly in order to ensure protection to the fundamental rights of the person that was submitted to such trial. The first time, the proceedings were stayed by order of the unanimity of the trial chamber, because prosecutor had refused to disclose to the defense information that was or could be considered as potentially exculpatory or material for the preparation of the defense. The statute in its Article 54.3 allows the prosecution to collect information that could generate evidence, collect this evidence under the condition of confidentiality. This information cannot be disclosed to the defense. What the legislator of the statute never thought about was the possibility that this information or evidence could be of potentially exculpatory or character. And the statute as well, in its Article 67.2, imposes on the judges the obligation, or on the prosecutor the obligation to disclose potentially exculpatory information. So the trial chamber saw itself in a situation in which they decided that the only way was to suspend the proceedings in order for the trial chamber to decide in this apparent conflict of fundamental rights, or between two rules of the statute, one involving a fundamental right provided for in the chapter of fundamental rights of the person submitted to trial. And at the end, the appeals chamber decided that the information should be disclosed, or that related information should be disclosed, in order to ensure that the prosecutor protect the sources, which is basic in a court like the International Criminal Court depends 100% on the cooperation of other states, of non-governmental organizations, on the UN or in other organs. So, find a balance between this obligation of confidentiality of the prosecution and ensure the rights of the full protection of the rights of the accused. The second time, the trial, Mr. Lubanga was suspended because the majority of the chamber had decided to include new charges. And there was a discussion on whether the judges could modify the charges in the middle of the trial. We can say that in many legal systems that are mostly based on civil law tradition, that would be possible. The so-called emendatio libelli or even mutatio libelli, in which the judges are entitled, having in front of them the evidence collected during the trial, the judges are entitled to change the legal characterization of the facts or even to add charges to those charges presented by the prosecution. In order to ensure that the trial would not continue before a decision on this possibility of the trial chamber to modify the charges, again the trial was suspended, awaiting for a decision, a sovereign decision of the accused chamber. Finally, the Lubanga case was suspended a third time when the trial chamber, the judges, again with full respect to the rights of the person accused, decided to initiate an investigation related to the how can I say, the credibility of some of the main witnesses in the Lubanga case. The judges got the impression that some of the main witnesses, exactly some of or most of the former soldiers that were witnesses during the trial of Mr. Lubanga, had been trained by intermediaries in their testimonies. The judges understood that it was important to inquiry into the conduct of these intermediaries, persons that were in charge of non-governmental organizations whose purpose was to reintegrate children, child soldiers into society, rehabilitate these children, but at the same time, apparently, some of them use these children in order to contribute in providing evidence to the prosecution by coaching, by training, really, these witnesses. And at the end, in preserving the fundamental rights of the accused, the testimonies of these, many of these child soldiers were excluded from the evidence, and these very same child soldiers had their right to participate as victims in the case also revoked. So at the end, I think one can say this is not an excuse for someone to stay in jail for 6 years, or these are not excuses. But in a way, when we talk about the first case of the International Criminal Court, whose objective was to set out the first parameters in international justice, coming from the very first permanent criminal court, we think that the result cannot be overshadowed by the difficulties faced by the judges and by investigators, and why not to say by the mistakes committed by prosecution. I think in the Lubanga case, everyone has learned from their own mistakes, and the international community should see this as an advance in international law instead of seeing the glass half empty in terms of international trials. Of course, we cannot never imagine that a trial before an international court will have the same length as a trial before a national court. The International Criminal Court has almost a universal jurisdiction. In the cases that we have before us currently, we have suspects, accused, and persons that speak at least 10 different languages, not only French and English, but Arabic and 6 or 7 different dialects from Africa. All documents in order to ensure the protection of the rights of the accused, the main documents of the case, the documents containing the charges, or better say, starting by the warrant of arrest and the decision granting the warrant of arrest, the document containing the charges and all decisions on the merits, plus by explicit rule 76 of the Rules of Procedure and Evidence, all witnesses' statements must be given to the accused in a language he fully speaks, reads, and understands, which is not an easy task. I was mentioning yesterday that the decision on the merit in the Lubanga case was a 600 pages decision, can be criticized by its length as well. But in any case, was a decision in English and till now was not notified on the accused because it will take about 6 months to be translated into French because this is the language the accused fully speaks and understands. So before he can file an appeal against the decision, there is the need to translate this very lengthy decision. So, justified, maybe not as an excuse, but a justification on the length of the first case of the court, and just making it clear that the second case of the court, the case of Katanga and Gujru, has finished already the presentation of evidence by both parties and has taken less than 5 years. And now the third case that is on trial, the Bemba case, will finish for sure before 4 years from the beginning to the decision on the merits, which in my view shows very clearly that the court is improving its proceedings. It's getting better. It's going to be better in relation to pre-trial proceedings. As I said, the Lubanga pre-trial proceeding took 1 year and 2 months. The following ones less than a year, and the current case that is before pre-trial chamber 1 for the confirmation of charges, it will take 5 months. So I think the court deserves some credit and some patience from the part of the international community and the legal community, and to pay attention to the merit and to the very important points that were discussed in the Lubanga decision, starting by the discussion on criminal individual responsibility, which is really a landmark. It differs from the jurisprudence established by the ad hoc courts, the International Court for Yugoslavia and for Rwanda. It's landmark. It's an approach that, if kept by the English chamber, will help even the national jurisdictions to deal more easily with the so-called transnational crimes, because it recognizes the form of responsibility based on control of the crime. It refers specifically to the form of responsibility of the immediate or responsibility or perpetration through another person, through the structures of power, which is the only way in which we can get the most responsible for not only international crimes, but national crimes that to be better dealing in national systems. I would like just to finalize, and we'll leave more space for the debate, of course, and I'm sure there will be a lot of debate. Just to mention that till this moment, at least 4 cases referring to 4 accused, the charges were not confirmed by the International Criminal Court, which comes or brings the very clear idea on how cautious judges are in order to send people to trial or not to send people to trial, persons that under other circumstances would be sent to trial and to a trial that will, with no enough evidence to establish the guilty beyond reasonable doubt. We anticipate that in not sending these people to trial, the important decisions issued by not only pre-trial but trial chambers of the court in relation to disclosure of evidence, witnesses protection, witnesses participation, which is also a differential of the International Criminal Court in relation to the other courts. So I am sure that the Lubanga trial has made the first steps along the path which subsequent trials or proceedings will follow. It's important that we recognize our mistakes, we learn from our mistakes. We've been in trial enjoying the precedents of ICTY and ICTR, precedents very important in terms of establishing some standards in international law, international criminal law. And so we learn from the good precedents we have, and we learn from the mistakes we made and the mistakes made by other tribunals. And for us in the International Criminal Court, it was definitely an exciting day. The day the court, the Tri-Chamber 1 issued the summary of the decision on the Lubanga trial. And it was not just because Angelina Jolie was there. It was a moment in which we could remember the struggles we had to work at the beginning of the court, in building up a pre-trial procedure that was something completely new in international criminal law, in international criminal procedure, without any precedents in which we could base our findings. So the struggle of the judges, of the officers, of the victims unit, of the interpreters, of all agents involved, the struggles in establishing standards for victim participation. We started the Lubanga case with 3 or 4 victims participating. We have now the Bemba case, which I preside in trial phase, almost 4,000 victims participating. It shows that at least in relation to the victims that our main target, the confidence on the court is very strong and continuous, and we hope we can give to this community, mainly the community of the victims, the kind of justice they, in our view, they deserve. Yes, we have accusations that we are always targeting Africa. And so I must say that in a way we are targeting the victims of Africa, and we are of the view that the victims of Africa, they deserve a very sophisticated court, very costly court, as our court is, and because it's for the first time that we have an international permanent criminal court that pays attention not only to the retribution or to the retributive justice, but also reparation and giving some hope for the victims victims of the most serious crimes. So my glass continues half full. Thank you very much.
You have also important.
Thank you. It's a pleasure to take the floor in this debate. And I wish first to thank the Academy, Professor Grossman, for inviting me to this, and the American Society for inviting me here to an institution which, on one hand, a newcomer, the Academy, in the Basil, I'm a veteran in the sense that it's almost, I think, 50 years ago. Now, Judge Steiner put me in a slightly uncomfortable position because she started on the defense and put the court at the center of a number of accusations and tried to defend from all the accusations, and it did well. So if I insisted in accusing, that would be really unfair. And I will not try to rebut her arguments in favor of the court. Rather, as a member of the oldest International Criminal Tribunal, the ICTY, I wish to congratulate first the ICC for bringing to an end its first trial. It's important. It's an important achievement to have shown that justice works and a trial can be finished successfully. And I wish especially to congratulate Judge Steiner because she played an important and direct role in this achievement. One can only hope, I think, that Lubanga case, although Lubanga certainly is not the highest rank accused before the ICC, may in a few years be regarded as Tadic, who again was not a high rank personality, the first case before the ICTY, and would hope that reference will be made to Lubanga as it continuously is made to Tadic. Now, I resist the temptation of rebutting some of the arguments made by Sylvia Steiner on some of the experience of the ICTY could have, if taken into account, could have remedied situations rather easily and may still remedy them. So I will limit to this, to the appeal. I don't think it's necessary to wait the translation to start with the appeal. Counsel is speaking the language, and counsel can start the appeal. We use that practice. We let counsel start the appeal, and then when the accused will have the translation, he will be allowed to motion for changing the grounds of the appeal, changing the appeal brief, changing the appeal documents if he so wishes, but always showing good grounds for doing so. One thing that may be shocking in a way for me in listening to all the difficulties in conducting quickly a trial and looking at the length of the trial is that the ICTY was always accused of conducting slow trial. It's a fact that as of the beginning, although they were shorter than but still too long for criteria that are normally applied in domestic jurisdictions, where would not be tolerated to have cases that last so long. I remember when joining the tribunal, my first concern was the length of the proceedings. And I waited with some concern, counsel for the accused, counsel asking me in court, Judge, you have been for years telling states in the Human Rights Committee that they had to accelerate their case, and now they're doing. You were telling others to do what you are not able to really do yourself here. But it did not happen, luckily, because they would not have had a real answer. But what's shocking is that the accusation that our trials have always been too long was made dependent on the common law approach of our procedure and of our rules of procedure and evidence. Now, the ICC is taking the opposite approach. It's taking a civil law approach rather than a common law approach. And apparently, the procedures are even longer. So there is something that we should look into. Is that really a problem of the background, of the inspiration of the procedure, common law or civil law? I have come to the conclusion in general, but I haven't looked in depth at the procedure of the ICC, that probably it's not a question of relying on civil or common law. The fact is that the international procedure has been shaped in a different way. It cannot just be like a domestic procedure. It's not possible to transfer a system, a methodology to the international level. And probably new ways have to be devised to find a solution to this problem of the length of the trials. That will eventually result in not doing justice, not in specific cases maybe, can be justified in specific cases, will prevent courts from dealing with a number of cases that would require to be dealt with or would delay excessively taking future cases. But I wanted to dwell on something else, to a more legal argument, instead of discussing only the delays in the procedure. Precisely because the Lubanga case may be a future reference, I would like to discuss a couple of issues which may be of future significance in the development of the law, in the development of the International Criminal Court. And they have to do with the law applicable before an international court, and at the same time with the principle of legality. The principle which is imperative, as we know, in international law, in domestic law. Principle has been stressed and reiterated in all human rights instruments, without exceptions. The nullum crimen in a major principle is a principle that nobody would dare to discuss. Nobody would dare today to discuss that nobody can be prosecuted and convicted for a crime that was not a crime established by law at the time of the commission of the crime. And if we look at the two tribunals, I'm now comparing the ICTY and the ICC, the principle of legality, the respect for the principle of legality has led to different approaches in the two tribunals. In the ICTY, the respect for the principle of legality has obliged the ICTY not to rely on its statute as a substantive applicable law, as the statute was adopted after the commission of at least part of the crimes falling under the jurisdiction of the tribunal. And this has led the ICTY to rely essentially on customary international law and to a limited extent to treaty law, following an indication that was confirmed later in the Tadic case by the Secretary General when submitted to the Security Council the draft statute of the tribunal, recommending to apply rules that could be regarded as no doubt part of customary international law. The ICC has a different approach because it has jurisdiction only for cases, crimes committed after the entry into force of the statute for the state or the person concerned. And therefore, the statute and the elements of the crime, the document contains the elements of the crimes, cannot be regarded easily as the law applicable to the cases. A sort of criminal code, criminal statute can be applied to the case, to the various cases. And customary international law plays a sort of subsidiary role, supplementary role, occasional role. It's not very clear because Article 21 of the ICC statute establishes that in the first place, the tribunal, the court will apply the statute in the elements of crime, and in the second place, other rules, other treaties, treaty law, or principles of international law, including. It doesn't refer specifically to customary law, but speaking of principle of international law, clearly customary law is in. But the reference to these other sources of law is preceded by the words "where appropriate." Now, those who are familiar with the United Nations language know very well that the words "where appropriate" are very frequent in all the resolutions of the General Assembly, in the resolutions of the Council, and means that there is no consensus, essentially, and everybody can do whatever he wants, deciding it's appropriate or not appropriate to take a certain step. So we have two different approaches to tribunal to respect the principle of legality. And so far so good. There is no problem because there is a justification for the different approach. And it would be obvious that an issue of legality should never arise with the ICC because the crimes come after the law that has been adopted and described as crimes. But at least, should be no problem, at least when the ICC exercises jurisdiction, the ordinary jurisdiction, when it goes to exercise jurisdiction on referrals by the Security Council, situation may clearly change because it's not obvious in those cases that the statute can apply exactly to respect the principle of legality. In crimes committed in countries that did not ratify the statute is a treaty, and you all know that the treaty is not binding for states that have not, are not part of the treaties. But for the ordinary jurisdiction of the court, the problem should not be federalized, but in the Lubanga case, it arose. Was one of the main arguments of the defense. And the court resolved it, of course, resolved the problem, saying that the principle of legality was respected, and I concur with the outcome of the deliberation of the court. But the way it went through the problem, in my view, is a bit curious, and perhaps the court could have done it better. It could have argued on this question in a better way. Of course, I'm not challenging the outcome. I'm not challenging that under international law it is a crime enlisting, recruiting, or using minors under 15 years of age for military purposes. But the way it has been done, that it may be debated. In the decision where this problem is taken up by the court initially refers to the statute, says this is a statute. This statute came into force in July 2002. The crimes committed are after July 2002, so there is no the principle of legality is suspected. But having said that, the court engages in a discussion of an argument of the defense that the accused was and had reason to be unaware of the criminality of his behavior. And that's because, first, the ratification of the Democratic Republic of Congo occurred only a few months before the crimes, which means that the entry into force was very, very close to the commission of the crimes. And putting another series of arguments in this respect. And the court goes into a discussion, in fact, and in law, of this question of unawareness, awareness, when it could have stopped, either stopped at saying that happened after the court was the court statute came into force, or could have simply referred, and they would favor this approach, to customary international law, to say customary international law already provided for the crime, and had a precedent, a clear precedent, although it was adopted by majority, of the special court of Sierra Leone that had decided precisely the same case and had come to the conclusion that under customary international law, as of the 80s, this was a crime. And referring to that, all the question of awareness, non-awareness would have been dropped easily, because it's clear that if under customary international law there is a crime, we are in the field of imperative law. It's obvious, imperative international law, it's obvious that nobody can say, I did not know that the law existed. It's part of an approach that it's true. The chamber makes in passing a reference to the precedent of Sierra Leone, but in the middle of pages in which it engages in showing that it was prohibited under the law to recruit the children, which per se does not explain enough that it is a crime, because the prohibition under international law is not necessarily criminal. I mean, violating the prohibition. And this is one of the difficult issues before international courts, which the Secretary General, when it sent to the Security Council the statute of Sierra Leone, specified in particular with reference to children, soldiers. The Secretary General warned the Sierra Leone court, saying that the prohibition of child recruitment has no doubt acquire the customary international law status, but it is far less clear whether the customary recognizes a war crime entailing individual criminal responsibility of the accused. Now, when we reason of the Geneva Conventions, we have a relatively easy work because the Geneva Convention has the great bridges that are crimes. But when we are outside of the great bridges, it's not so obvious that any prohibition entails criminal responsibility. But precisely the Court of Settlement had given a solution of the problem that made all the example. I think the ICC could have easily based a solution on this and would have done something useful in my view, because Article 21 is not very well drafted on the sources of law. And I believe that if the ICC had made use of customary law, had worked in the direction of harmonizing the use of the sources of international law, and that would have been and would be still in the future beneficial for keeping a unity of international criminal law, which and may allow the court to make more use of precedents that are based on customary international law, because all the bodies of case law existing today in international criminal law is essentially based on customary international law and not on states or things. So this was just something I wanted to say, not to criticize the court, but maybe to recommend that better use of the sources be made. And it's a responsibility for the court, because the state's party did not draft Article 21 very well.
Now I'm going to open the floor for questions, and perhaps using the parliament here and to promote the dialogue. I wanted to ask a question that perhaps comes from my experience in the Inter-American system. The first case before the Inter-American Court of Human Rights was the case of Manfredo Ángel Velasquez. Disappearances in America. I know very well the case. I was not yet in the American Convention, but I was one of the lawyers representing the region. And we had suffered at that time in this region widespread violation of human rights, dictatorship, and so on. There are multiple violations. Summary executions, due process, discrimination, lack of due process. But there was something particularly abhorrent, and that was disappearances. It was very important to expose the issue of disappearances and then to capture at that moment what was the most important issue facing the region. So my question perhaps goes to the matter of prosecutorial choices. In more than the work in Congo, we saw since 1998 4.3 million killed, individuals killed, rape, torture, disappearances, and so forth. So, to a certain extent, from the point of view of the contribution of the court and the case involved a serious matter of conscription of children. You know, and of course contributes because it's a rejection of impunity, but there is a sense that, or at least by some authors, that perhaps the prosecution should have gone to a more abhorrent situation. So I wonder whether you have, because that links, I mean, there is an educational role, that of course is good, there is a rejection of impunity in the matter of child soldiers. So why that prosecutorial discretion choose this topic and perhaps also prosecute and not torture, disappearances, the killing of human beings. And then, that's point one. And point two, when we read the dissenting opinion of Judge Olive, where he said also very narrow, in her view, interpretation of the use of children, exposing them to danger in a combat situation. I mean, it's not exactly that, but there are some issues there. And she said one, or her dissenting opinion, talks about the fact that these children are also used as sexual objects, and so the majority of the court did not put that also either. So there was a selection, perhaps it's a prosecutorial, in the first, the selection of the topic who leaves a sense of the most important issue. And that does not mean that it's not important, the issue of the conflict of shepherd. And then the second thing, and it's not a value in itself, like you think where you have more value. And the second issue, a interpretation of the child soldiers, putting them in a situation of danger in combat situations, and not the danger created by their own group. And again, there is space for progressive interpretation in the future, the language is not open, but still that led to a okay. So again, that relates perhaps to the prosecutor, the first part, but not the second. So I wonder whether you have any interpretation why this was chosen and not without any comparison. We know that Al Capone, that's the theory, was captured on not paying taxes for cigarettes. I haven't checked that situation. But here there are overwhelming evidence of that. This is also related to a criticism that we have, of the importance in Africa of the fight against colonialism, mentions of death, people that have supported these things. So the context was a little bit absent by defining it narrowly instead of the broader. So what's your interpretation of what that happened? I think in the literature this is one again will be
Thank you very much, Professor Brosnan. So this is one of the points that have been discussed for the past 10 years, is the problem of prosecutorial discretion. So I'm not in a position to, I don't have mandate from Mr. Moreno Campo to explain why he chose one situation and not the other, or he picked and choose one client and not the other. So the information I have is the same information that the public in general has. In relation to the first case, the case of Thomas Lubanga Dyilo, what I can say, because I was at the pre-trial chamber when the case started, is that was a very recent report. It was had been appointed by the General Assembly of the United Nations, a special rapporteur for the Democratic Republic of Congo, with the main purpose of elaborating a report on the use of children in the different parts of the conflict in the Democratic Republic of Congo, because it was then the report that was presented to the General Assembly confirmed that in all militias and armed groups in that time, in the period 2002-2003, all militias were composed, at least 50% of the soldiers were child soldiers. So I think at that moment the prosecutor was moved for the need to choose a case, and I don't like to use the expression symbolic, because I don't like the idea of symbolic in criminal law, but more emblematic in that moment, because that was one case that was really of concern of the United Nations. It followed the publication of one previous report prepared by the previous rapporteur, Madame Graça Machel, and that was transformed in a very, very good book, Children in War, or War on Children. And so I think it was one issue that needed at that moment to be dealt with in order to show to the international community that this kind of conduct would not be tolerated anymore. And at the same time, I must say, I was reading very briefly these documents that were given to us in the entrance, that are comments from Human Rights Watch. And a very, very quick look gives me the impression that all criticism that come from Human Rights Watch are related exactly to the choices made by the prosecution. Some of these criticism may be disputable. In relation, for instance, here what I see in the Central African Republic, which is the case that now I am presiding in trial. So the main criticism is why only Mr. Bemba was prosecuted and not Mr. Kabila. Yeah, I think we could ask the prosecutor why, but that doesn't take from the Bemba case its importance in the sense, and the second question of Human Rights Watch, why to prosecute Mr. Bemba for the crimes committed in Central African Republic and not for the crimes his armed group committed in Democratic Republic of Congo? This question I can answer because in Central African Republic there was another emblematic situation. The troops of Mr. Bemba went, or alleged to have gone to Central African Republic with the only purpose of eliminating or destabilizing the troops of Mr. Bozizé that intended at that time a coup d'etat. But the warfare, the tool of the war in Central African Republic was the rape of women. So we are facing a case in which very few people were killed in the attack, but we have 3,000 women victims of rapes or massive rapes allegedly committed, I repeat, there is no decision on the merits, but allegedly committed in Central African Republic by Mr. Bemba troops. So it was again a prosecution's choice, and I'm not saying it was a good choice or a bad choice, but the apparent justification was for the emblematic character of this kind of attack that uses the sexual violence as a tool of war. So I think it would be a very good opportunity. Mr. Moreno Campo, as from Friday, is not anymore the prosecutor of the International Criminal Court, but maybe to be called and to give some explanations. Maybe now we can feel free to explain to the community as a whole why the reasons of his choices sometimes that appear to be not as a result of discretionary powers, but sometimes appear to be a little bit arbitrary. I agree with you, but we don't know the reasons behind the prosecution choices. And just one last comment in relation to the crimes of enlistment and recruiting children and the partially dissenting opinion of Judge Olio Benito, one of the best judges at the International Criminal Court. This was exactly the subject of the second suspension of the case, whether the charges, after listening to the prosecutor evidence, whether the charges of using children in hostilities could be broader in order to include the use of children as sexual slaves. And at the end, it was concluded that it should be a new, this would consist in a new charge, because when we used exactly international customary law in this case, and precedents of the international courts, and the interpretation given to now of the Red Cross to the crimes in saying that the use of children includes not only the use of children in the battlefield, but the using of children in whatever kind of activity that could put the children in danger as combatant. So it's not specifically referred to the personal position of the children as a sexual slave or domestic and doing domestic works for the soldiers. Nothing prevents the prosecution to bring new charges against Mr. Lubanga and the other leaders of militias for these charges.
Thank you very much. Thank you very much. We'll certainly give Ocampo a phone call and ask him what went on here. Now, we have invited him, as a matter of fact, he has been in our academy several times. It would be great to continue conversations with him. I wanted to offer the floor for anyone who wants to formulate a question, a comment, with the only requirement that you give your name, affiliation, social security number. Your name and affiliation. So, anyone? Yes,
Yeah.
please.
Hi, my name is Nicole Tifo. I'm a LLM student from American University. I'm doing my specialization in
Wait a second. In order to be memorialized for eternity, you need to speak.
Hi, my name is Nicole Tifo. I'm a LLM student in American University, and I'm doing my specialization in gender and human rights. And in one of my class last semester, we talked about the Akayasu case. There was that in the ICTR, where actually the court played a very important role to include and actually make the prosecutor brought the charges about like sexual violence of the victim. I wonder if that it's possible that this same logic will be applied in a near future in some judgments of the ICC. I don't know, because a lot of new facts were brought by the victims in the testimonies and videos, and I kind of like ask about like if the court can have a more proactive activity in order to make this evident violation of human rights and make the prosecutor to work on it. We are talking about an international court that is different. As Judge Fausto was saying, we cannot apply the same standard of the domestic court to an international court. I wonder if you can make some comment about that.
Yes, right. Overall, this challenge.
And I don't know exactly what the court will do, but certainly the court has, the judges have more weight in the choice of the prosecutor than it was in the ICTR, where the discretion of the prosecutor is 100%. So no possibility for the judges to go and direct the prosecutor to do anything on charges or ask the prosecutor to add new charges because the evidence shows that there are other possibilities. It is for the prosecutor to ask for an amendment of the indictment, if he so wants, during the trial, but if he does not do it, there is no way that the judges may ask anything to the prosecutor. I understand that in the system of the court, the pretrial chamber can direct the prosecutor to investigate in a certain direction rather than in other directions. And I think the court should do it. I don't know what it does, but should do it, because of course if you put two judges speaking of a prosecutor, it's easy that the prosecutor will be attacked. And I don't want to defend Moreno Campo, whose reputation maybe is not the best one nowadays, but the fact is that the prosecutor, if he is alone, has an enormous responsibility. And if the international community chooses one of the judges as not the best judge, it doesn't matter. There is a group of judges doing the work. But if it's just one person taking all the decision, and that person is not the right one, all the system collapses inevitably, because you can't have a good trial, you can't have a successful outcome of the trial if the prosecutor is not at the level to deal with that. And to choose also the subjects. It's clear that if you have a situation like the one in the world nowadays, with crimes committed frequently, it's difficult for the prosecutor to make choice. Because the capacity of the court is limited, and choosing one means excluding some, or delaying, who doesn't know for how long, another one. So I know there is debate in choosing not on the basis of the gravity of the crime, of the culpability, say, of the alleged perpetrator, but on the subject matters. There will come something that Professor Grossman was saying, why don't you choose a subject which is more important at the moment, like would be all this sexual violence crime needs some clarification, because the tribunals, the existing tribunals, did a lot on this, not only the AKS, the STY, very much in defining the crimes and advancing the law, but it remains. I read on a piece of news a few days ago that in Bosnia it's thousands or 50 or 60, 80,000 of rapes that occurred during the situation, and not more than 15, 20, 30 perpetrators have been brought to justice. So there is a real problem to discourage methods of war based on sectors. So I believe this should be a topic that the ICC should take up. The child soldiers is important, no doubt, but the Sierra Leonean court had already taken a stand on this. Had already described the crime, had already dealt with it. In my view, I wouldn't choose that. Maybe, but of course a prosecutor may have the evidence on a case and not have the evidence of another case. Or may believe it will be easy to arrest one person and not easy to arrest another person. So the choices may depend also on various situations. The ICTY, the first case, Tadic, was by a chance. The Tadic was because it wasn't possible because of the war, the ongoing war, to arrest anybody, in fact. But Tadic was in Germany. It was brought before the German courts. And based on the principle of priority of ICTY jurisdiction, the ICTY said, well, with the German government, you said this guy here. And although he was facing justice in Germany was obliged to send it to the Hague. And the tribunal had a case, otherwise we would have no accused in those cases. Wanted to start the work. So it didn't matter the rank of the accused, it didn't matter the type of crimes. But that was different because at the time the ICTY had to start from something in any event because there was nothing before.
Let me just,
Yes,
in order to add something to what Judge Pokar rightly pointed out. At the ICC, the judges of the pretrial chambers, they are empowered to review a decision of the prosecution of not to prosecute. And we've been understanding giving a very large interpretation that not to prosecute should include, for instance, not to prosecute in the Lubanga case, the the sexual crimes committed against the child soldiers. The problem is that we are also bound by the principle of legality, and we can only review a decision of the prosecutor. And the prosecutor never took a decision not to prosecute. So every time, or many times, not only in Lubanga, but in other cases, when pre-trial chambers requested from the prosecution information about investigations related to other crimes, the answer is that investigation is still open. So the chamber cannot review a decision that has not been taken. And there is no rule imposing, let's say, a deadline on the prosecutor to take such a decision. Is a loophole in the rules of procedure and evidence that we hope the Assembly of States Parties in the near future, when revising the rules of procedure and evidence, can take care of this. I give a concrete example in the second case of the court, the case against Germaine Katanga in Machunbujro, that deals with one attack in one day against one village, Bogoro, with 300 victims. And I'm not saying that we give more importance to numbers to quantity, but just to compare, just to show you this problem of the discretion of the prosecutor, 3 days before his attack on Bogoro, the same armed groups attacked another village called Nyakunde, in which there were 1,200 casualties. And in that occasion, that many times the chamber wanted to have a more proactive way, asking the prosecutor, why Bogoro, not Nyakunde? Why not both? Or 3 or other villages that were attacked all in the same week? And the answer of the prosecution has been always, the investigation is still open. So we are investigating everything. So we have this some legal constraints that we cannot go too far against the rules when the rules are explicit. We can interpret when there are some lacunas, when there are this non-existence of rules, but when the rules are explicit, we have a very limited margin for interpretation.
Yes, please, in the back.
Hi, my name is Valentina Lukata, and I'm a master's degree student in international human rights law at American University in Cairo. First of all, I'd like to thank you for your speeches. They were wonderful. My question is related to particularly ICTY's mandate in terms of one of its goals or tasks was to tell objective historical account of the conflict that took place in Balkans in the 1990s. And my question is whether that's realistic in the first place. Can history be objective? Can ever be told in an objective manner? Should the International Tribunal, a legal court, ever be one put in a position to tell the history? And how does that influence the idea of justice being brought to these victims? The latest reports coming from Belgrade, Sarajevo, and Zagreb tell us that the ex-Yugoslavian countries and their population do not have a very high opinion of the courts for many different reasons. They're very much detached from its work. They have very low understanding and knowledge of the cases brought forward. And so in all that, and within that context, is it possible for a court that is physically and then conceptually distracted and detached from those who is supposed to serve, able to tell objective history? Thank you.
I wanted to propose that if there are 2-3 questions, and then we give an opportunity of participation for everyone. Are there more questions from the audience? Yes?
My name is Diana English. I work at the State Department in Rule of Law Development, but I also volunteer as a crisis counselor with the victims group here in DC. And I wanted to ask, you had mentioned, and I know that one of the important things about the ICC is the way that it interacts with victims in a sort of novel and new way. And I'm wondering if you can talk a little bit about how that played out in the Lubanga case. How was that real in the sort of processes and actual execution of that case?
Great. Any other question? Yes, please.
Hi, my name is Eric Sigmund. I'm the legal advisor for the International Humanitarian Law Unit at the American Red Cross. And my question concerns the deterrent function of the court. We saw after Lubanga and now most recently the Charles Taylor case that rebels in Liberia and now the United Nations just indicated, I believe yesterday, that Syria is using children as shields, human shields. What is the deterrent function of the court? Can the ICC itself prevent these atrocities from happening in the future?
Judge Pocard, you want to start and then we will go to it?
Okay, yes. Well, first the question of the historical record. I personally do not believe it's part giving of establishing an historical record is part of the function of the court. Because in any event, the court will establish what is first a partial record, also on the cases it deals with, and a judicial record. Because it really depends what is brought before the court. And it is for the parties to bring, for the prosecution to bring the evidence. The evidence may not succeed, and the person is acquitted. It doesn't mean that the crime did not exist. This is for historians to decide to make the full record. And as to the distance of the tribunal from the place where, and the environments where the crimes occurred, that is absolutely true. And one should perhaps consider revising the approach. Apparently the international community was moving towards another approach after the ICTY, ICTR, and ICC, because the statute was adopted in 1998, so it's quite old, although it entered into force later. But after that, the proliferation of courts continued, but went into hybrid courts established in the countries concerned. So local courts or mixed court with international judges appointed internationally, but still working on the place where the crimes occurred, so close to the society affected by the crime. It's so in East Timor where it didn't work correctly, in Cambodia where it worked to a certain extent, but even the ICTY had this problem, and indeed at a certain moment a court in Sarajevo was established, a state court for international crimes, that is a hybrid court comprised of judges from Bosnia and judges appointed by the High Representative for Bosnia. Now that experience is gone to the end, but that court did a lot of work and did that work on the place. At the end, it will be for domestic courts to make justice. As always, you cannot replace domestic justice by international judges on the long term. What would be important is to establish a link between the international activities of the court and the domestic court. But this cannot be done entirely by the tribunals. We did a lot of that. I remember when I became president of the court, that was my main concern, to establish links with the domestic court's importance, to continue the work, to work along our lines and work together for some time and establish sort of partnership with some courts that deal with Oceania, especially in Belgrade, especially in Bosnia. Croatia was less cooperative on this, but still also with Croatian judges that were made. But a court can do what it can. It needs international support to do that. It can be done because the judges have to do their work. They cannot engage too much in traveling in the region, working with the judges there, trying to help capacity building on in the area, trying to have judicial institutions training future judges in order to deal with these kinds. But at the end, I think the legacy of the International Court will be measured on how it could, at least the legacy in the areas concerned, will be measured on how it could transfer knowledge and push the local jurisdiction to do the work. It's essentially the same that happens in all the human rights field. You can't transfer the protection of human rights to the international level. At the end, you must protect, you must be given by domestic jurisdiction. What the international system can do is try to push and the domestic jurisdiction to do the work. So it's the same approach. Will the ICTY succeed? It's still to be seen. It will depend on how the domestic institution will work. But much more effort should be done in this respect. For the ICC, I think it's the same issue. Because at the end, Lubanga is, but what of the others that are recruiting children, the ICC will not be able to do it. The lack of resources.
Yeah, just following what Judge Pratt just said, and I think it's answering to your question. I think it's not a function of any court to put an end to criminality. It's to try to put an end to impunity, which is different. So sending the deterrent effect is in sending a message that impunity is not going to be tolerated. But one of the main functions of the ICC, even because the ICC has a complementary jurisdiction, is to help and to even impose on states the obligation to implement the crimes and to have personnel in the judicial institutions, the prosecutions, able to exercise the jurisdictions themselves. So I think the ICTY, the ICC, the hybrid courts, they are just a step. They cannot be seen as an end in themselves. I think I would like to compare with the national system. So you have a criminal code, a criminal procedure code, and it's put on for the benefit of the community in order to bring to justice those that committed crimes. But I have my doubts on whether the deterrent effect of a criminal system is then enough to put an end to criminality. Unfortunately, I think this would be a very ambitious purpose of international courts. In relation to the question put by the colleague and on victims' participation in the Lubanga case, in the Lubanga case, in the pre-trial phase, we started by allowing victims to participate even at the investigation stage. This decision has been reversed by the appeals chamber, saying that only on criminal proceedings before the chambers, victims would be allowed to participate. But what I can say is that although the number of victims is not too high in Lubanga, that they had a very, very effective participation. So showing that the participation of victims in the statutory framework is not just for the purpose of reparations, but mainly for the purpose of effective participation and to have to be heard. We are recognizing based on mainly on the jurisprudence of the Inter-American Court of Human Rights, this fundamental right of the victims, which is the right to be heard. And we had, I think, 100 and something victims participating in Lubanga, 400 victims, more or less, participating in Katanga, and in Bemba we have 4,000, which means that let's say, the credibility of the court in terms of allowing victims to be heard, it's been recognized. Victims in the Bemba case, which is the case I preside, they have presented evidence, they were entitled to question witnesses, but the prosecutor will be authorized to question the witnesses from the defense. And in 2 weeks, we are hearing 3 victims that are not testifying at all. They are coming with the sole purpose of telling their stories. So it's a space that was open for the victims just to give them a voice. We cannot, of course, allow 4,000 people to come, but the legal representatives of victims, they choose 3 victims that in the views of the legal representatives are quite strong, have quite strong stories to tell the world. And I think this is a very important achievement for the court. And so I think this was the main points I would like to tackle.
Well, coming to a conclusion, I want to thank all of you for being here. Your presence by itself shows the importance given to International Criminal Court. I think we'll appreciate also the strengthening of the message in this case that individual responsibility is very important, and that the rejection of the impunity, the need for accountability and support. We also have seen how the length of time to adopt decisions has been shortened, and I think that that's a positive development. And a very important positive development also is this discussion that shows that how we can contribute to reason on these matters, and by talking about this, perhaps the education and role that we are mentioning and the internal role is strengthening. Well, again, thank you for your presence here. Thanks for the American Society, and we invite everyone to continue social.